Welcome to the Real Property Law Section's What's Up With Us, August edition. I'm Neil Kalin. You just heard from Ashley Peterson, and you're also listening to Eric Hawes, who's going to be our special guest today, and we're going to interview Eric a little bit later on in the program. So let's see what we've got going for today. Hey, this is our last What's Up With Us for the CLA year. The next year's term starts on September 19th, and our next What's Up With Us is on September 21st. So that's going to be a whole new year with some new people. We have 5 cases that we're going to somehow try and whip through today. First, we got the Marina Pacific case, another COVID-19 case. So they're still working their way through the system. And then we have a very interesting case, Martinez versus Cotton Wash, which deals with, websites and whether they're subject to the AGA. And there was a discussion last week with a different case. We'll bring that up as well. We're going to interview Eric Everett Hawes. Eric is going to make a great interviewee, and I'm sure he's got some things to say about our cases. And then we got like 3 cases that we'll kind of deal with all at once. Nunez, Joshi, and Montes, which all deal with basically premises liability, and all came out with essentially defense verdicts, although they didn't really go to trial. But they all had a defense judgment, I guess, for them. So kind of interesting. And we'll end up, as usual, with some RPLS upcoming events and education. What I wanted to start off with, just to let you know for next year what we're going to have. So our new chair of the Real Property Law Section is going to be Sean Dillon. And then we have carryovers, France, Michael, Mark, and Kyle, and some more carryovers, Mary Beth. Well, Svetlana is sort of a carryover. She's kind of joining a midterm. Eric is still going to be with us, Megan, Timothy. And we've got 2 new members next year, JJ and Mark. And you can see the activities that they're involved in. So we'll have to get Michael signed up for something, and Svetlana signed up for something, and Tim and Mark signed up for something too. So there's a lot going on at the Real Property section, and want to be the first to congratulate everybody who's going to be part of next year's executive committee. And that takes us to our first case, right? We've got Marina Pacific versus Fireman's Fund. So let me tell you a little bit about this case. You can see very recent case, right? Decided last month. And when I put this presentation together, there was not even an official site for this case yet, right? So that's why we have the blank, the Cal Reporter 3rd. It's going to be there somewhere, but it is a second appellate district case. You got the full name. What happened here? Well, Fireman's Fund issued a commercial property insurance policy, a hotel, on a hotel, an adjoining restaurant for a 1-year period. The policy included a limited communicable disease coverage, but also had exclusions for mortality and disease that the court actually addressed, which is, how do you have coverage for communicable disease, but then have an exclusion for diseases? So that will be kind of interesting to those who follow this. The property, like all the others during the pandemic, starting in March, access was denied, right? Are very restricted for hotels and restaurants. And so what happened? Well, the owners put in a claim for insurance. And after Fireman's denied the insurance policy claim, as they've been doing all throughout the state, all throughout the nation, well, what happened? The owners sued Fireman's. And here was something that's a little bit different than we've heard in other cases. So the owners alleged COVID-19 was present on and physically transformed portions of their property, thus that triggered the direct physical loss or damage clause of the policy. Okay? The complaint alleged that COVID-19 bonds with and adheres to the surface objects through, and I like this, physical chemical reactions. Well, I guess, isn't it the same thing, Ashley? Like if you spill your Coke, doesn't it bond with, the table and create some kind of chemical reaction?
I think
I
so.
don't, so,
You're referring to a Coca-Cola, right, Neil?
yeah, right, to Coca-Cola, absolutely. Anyway, so the insured said, well, we had to adopt remedial, measures and precautionary measures to restore and remediate the errant services. Fireman's demurred, you guys have no claim. The trial court granted the demur. Trial court said that, the physical loss or damage must actually cause damage, physical change to condition of the property. If you really have it, take a cloth, spray it, with the things that you all wipe your hands with and wipe it off, right? The mere fact that it could survive allegedly for up to 28 days, the harm is temporary. So the insured's appeal. And here's what the appellate court said. They said, they discussed the standard of review for demurs. And they said the rules of interpretation of insurance policies, what do you do? Basically, if there's any kind of ambiguity or question, it should be decided in favor of the insured, right? And the court was discussing direct physical loss, looked at some other cases, so it was well-written opinion. But basically, the appellate court said, you know what? The complaint did allege a direct physical loss. And that's what the policy said it covered. Now, there might be a factual question as to whether there really was a direct physical loss, right? Which is sort of what the trial court said, which is, where's the loss? You can clean it up. It's going to be temporary. It's not going to stay there, forever. But the appellate court said, that's not what gets decided on a demur. What gets decided on demur is whether they alleged a claim within the confines of the policy. And the court said, this is not like, and this is a case that was discussed last month in What's Up With Us, the Musso and Frank Grill case, which they were denied use of their property, right, because of the shutdown. That's not what's being argued here. It's a completely different type of claim. The appellate court said, you know what, we don't have anything that we can take judicial notice of that COVID actually causes or does not cause physical damage, therefore, which would make a demur inappropriate. Therefore, hey, they're alleging coverage. The scope of damage, whether it's factually appropriate, we'll have to determine that later. And then I just threw in a line here. If you want to read the case, you'll find out later. But the court said, well, you've got these two conflicting provisions in the policy, right? One is for communicable disease coverage, and the other is an exception for communicable diseases. And the court said, well, wait a minute. Now we're going to apply those rules of interpreting insurance policies. We're going to favor the insured. So we're going to say the exclusion is not really going to take effect, but that will be decided later. I don't know. Tell me, what do you think about this case, Ashley?
Yeah, I think these attorneys deserve some props for really coming up with some creative arguments to say that there was physical damage for them to claim the loss. I mean, compared to every other case we've seen that has come out of COVID with these insurance disputes, they've been denied based on no direct physical damage or loss. So I have to say, these attorneys got very creative, and the fact that this insurance policy had specifically language that would cover communicable diseases, I think is what sort of set it apart from the Musso case that we talked about last month.
And you say the attorneys were creative. Look, when they filed the case in July of 2020, so this is just a few months after COVID started. Mm-hmm. So it wasn't like they had the ability to look at all of these cases that have been filed over the last year and a half or 2 years. Somebody came up with a pretty good argument really quickly.
Well, I think they actually really read through the language in that policy, and they're like, how are we going to argue this specific thing? Because that's going to be important for getting coverage. So I see Eric nodding his head. Do you want to chime in, Eric?
We'll also understand, I mean, the reasons are not the recency of the case, but the closeness of the case to the outbreak of COVID is somewhat interesting, because it was at a time where we were all wondering if surface contact could be the source of the COVID instead of air contact. And so that's somewhat fascinating that you mentioned that it was so close to the outbreak of the COVID. I mean, this is when people were wiping down their bottles of 409 and wiping down their groceries and such. So we didn't know the relation of the surface spread of COVID to the air spread of COVID, but also the court does a good job of telling you where it's going. Okay, demurs have to be based on the face of the complaint or matters which can be judicially noticed. And there is a lot of scholarship and a lot of decisions and a lot of treatises that talk about what can and cannot be judicially noticed. And the court talks about it, that these facts about the pandemic have not risen to the level to where they can be judicially noticed, but it's kind of giving a hint that it would rule differently on a motion for summary judgment, where you could have some development of evidentiary facts. So it's an interesting decision, but I think the key thing is you can't do this kind of thing on a demur, although later on in the case it would be proper.
Yeah, so it might be a good short-term win with maybe not such success later on, you know, if the matter doesn't settle, right?
Well, it's enough to get a more attractive settlement offer.
Yeah, sure. Okay, well, good. So let's move on to case number 2, which is something that, you know, affects all of our lives. Everybody shops online. It's a regular occurrence in today's world, and this California case really looks at this through a very interesting lens, and I think did actually a great job going through the federal cases that have discussed the issue, the California cases that discuss this issue, and I'm gonna make an observation in just a minute. But you know, first, just a real quick, you know, summary. What had Cotton Wash, you know, sells products online and only online. Does not have any brick and mortar stores. Okay. Martinez, a permanently blind person, uses screen readers to access the internet and read content. Sent a letter to Cotton Wash saying, my screen readers won't work with your website. As a result, you're discriminating against me. I'm in a protected class. They exchanged letters. Ultimately, the Cotton Wash people said, we're not changing, you know, our website to accommodate. Now, whether they could, whether it was too expensive, we don't know, you know, the reason why they were not making the change. And so Martinez filed a lawsuit, and he alleged violation of the Unruh Civil Rights Act. And part of that is because there was a violation of the ADA, American with Disabilities Act. CW demurred. The trial court sustained the demurrer, right, with prejudice. Martinez appealed. The appellate court went through and says, well, okay, first let's deal with these issues separately. So in order to state a claim under the Unruh Act, if just showing that there's a discriminatory impact on a protected class is not alone, there has to be intentional conduct. You just cannot have facially neutral content, which the court said, yeah, the website is facially neutral content. It does not particularly on its face make any distinctions between parties who are in a protected class or not. And the court said, the fact that it's difficult for the blind is evidence of impact, not intent. And then the court went through a really lengthy discussion on the ADA issue, pointing out the conflicts in the federal court, pointing out what's going on in the state court, and ultimately, and what was going on at the federal level. There's, court said, you know, this has been going on for 20 years. There's basically 2 entities that could have done something about this ambiguity as to whether the law applies to websites that have no connection to a physical location. And that's Congress and the Department of Justice. And both of them have refused to do so. In fact, DOJ filed amicus briefs in many cases. What they're saying is, well, when we filed the amicus brief, that's the official position of the Department of Justice. And the court said, no, that's not an official position. You can set regulations, but filing an amicus brief is not creating an official governmental position. And the court said, hey, the mere fact that the government won't act, that doesn't give us authority to do so. And here's my little, observation here. I was reading through this case, and I thought, reading through the opinion, that this could have been written by Supreme Court Justice Clarence Thomas. Just the way it was written, we're going to back off. We're going to take, we're going to limit what the courts do, right? The courts don't make the law, the courts interpret the law. And so I wound up looking and saying, well, I know this is a state case. Obviously, this is not, a U.S. Supreme Court Justice case. So I looked at it and said, could this be the anomaly in California where maybe you have two Republican appointees, on the appellate court? But no, it was two appointees from Governor Brown, one appointee from Governor Schwarzenegger. That's I was just kind of interested to see just the way the opinion was written. That was kind of surprising to me. Take it away, Ashley. Oh, you're on mute.
Sorry, I was having some feedback earlier. Didn't want to interfere. Yeah, I think I'm happy with how this case came out. I mean, I think it would create a huge burden on, small businesses and retailers who have to now modify all their websites if they don't actually have a storefront. So I'm wondering, as an attorney with a physical office, how that impacts my website going forward. Am I going to need to make sure that it's, ADA compliant with the, the screen readers capabilities and things like that. So, Eric, thoughts?
I have many thoughts on this one. I actually, in 2017, I defended a couple of financial institutions against claims that their websites were not ADA compliant because someone who was blind could not use them. And I learned a lot about this industry and this area of law very quickly. First off, it's a real cottage industry for the plaintiffs' attorneys. In fact, the plaintiffs' attorneys involved in this case were also the plaintiff attorneys in both of my cases. And also the case refers at page 10 to a Mrs. Thurston in a case that was from around 2019, 2020. And she was also the plaintiff in my case as well. So what they do is they'll find people, they'll just do a search for disabled people and then make them plaintiffs in cases. And again. And one of the states of Arizona and Nevada, the attorneys general moved to have somewhere in the nature of 2,000 cases dismissed because none of the plaintiffs could show actual damage from a violation of the ADA. And so in my cases, what I tried to do was have them removed to federal court because the federal laws are more friendly to businesses than the California cases. And unfortunately, Ms. Thurston was able to get them remanded into state court, and so we demurred. And one of the grounds of the demur was that a website was not a public accommodation. And there'd been no cases for the Ninth Circuit that really talked about it in this case. But what I noted is that the state of Arizona, and I believe the state of Nevada, had passed legislation that a website was not to be considered a public accommodation. So unfortunately, when I talked about how it's a cottage industry for the plaintiffs' attorneys who really do this on a hit and run basis, before we could actually get into that, my clients' carriers took over the defense, and they within a couple of weeks just settled the nominal amount and moved on. So we really couldn't. There were many defenses, including the model computer that Ms. Thurston had, could actually read all these things with the reader that came installed as part of the software when she purchased the computer, but we could never get to that. So it's interesting because there's not a lot of law in California as to whether a website is a public accommodation. And frankly, there's an issue as to whether under the Interstate Commerce Clause, where you could have it heard in federal court, because the internet is a borderless facility. So it's fascinating. I'm glad that there was some sense of common sense in the court decision as far as limiting these folks that are just brought up to be plaintiffs and to basically hit the businesses for a few $1,000s and move on to the next business. I remember reading a case where a ADA plaintiff went to meet his or her attorney at a restaurant to check out the sidewalk on which he or she slipped. And so they checked out the sidewalk and then they went into the restaurant to have lunch. And of course, the restaurant became their latest ADA claim.
So, Eric and Ashley, before we move on and start interviewing you, Eric, something, Ashley, I think will, interest you, but I haven't dug deep enough into the cases to figure this out yet. And that is, here we're talking about basically retail. And the issue is, will there be a difference in approach for service industries, right? As you say, you're a lawyer, you may have an office, but you are a service industry. You could perform your service over the phone. You could perform your service across state lines. I'm an attorney for the real estate industry, right? And real estate brokers by law are required to have a physical location, but most salespeople never ever go to that location, right? Mm-hmm. They meet their clients at the property. They meet their clients at a Starbucks. They meet their clients at their home or at their client's home, right? It's very rare that anybody in the real estate business will ever actually go to the physical location. And so they're kind of the next step for me is, what are the rules going to be? And will they be any different for service industry as they are for retail industry? So,
well, one of the things you can do, and you'll see the symbol on various websites, and I've seen the websites on relatively small service-based industries, is you'll see a little symbol that shows they're ADA compliant. And it's really not very expensive to get your website to be ADA compliant. For instance, in my case, 80% of the website could be read by a reader that comes with every computer you get. The only thing it couldn't read were PDF documents, which were the federal Regulation Z and such disclosures. So it's not that expensive if you want to ensure ADA compliance, just as for a physical location, an ADA inspection is a few $100s.
I'm sure a lot of people find that useful. Thanks, Eric.
Sure.
Yeah, go ahead. So, Ashley, if you have something else to go back to the case, if not, why don't you start letting our listeners know a little bit more about Eric?
All right. Well, we're very excited to have Eric here today. Eric is a member of our XCOM, as Neil had mentioned previously, which we'll talk about in a minute. But Eric, why don't you give us a little bit of a background about yourself and let people know who you are?
Well, I've been doing real property. Since I'm among lawyers, I can say real property and not real estate. But I've been doing real property and only real property since the late 1980s. One of the few pieces of good judgment that I exercised that early in my career was that I knew if I was going to be effective as a real estate attorney, I would have to do only real estate because it's too broad and too deep and too heavily regulated to do it on a part-time basis. So I've been doing nothing but real estate since the mid-1980s, and that deals with industrial properties, commercial properties, office building, agricultural properties, and that would include water rights and a lot of financing of the buying and selling of real property. So that's what I've been doing since the 1980s, and it's always fascinating. And you will never know everything there is to know about real estate. And I enjoy that.
So if you don't mind me interrupting just for a second, I'm curious, Eric, if you can, define this, what percentage of your practice would you say is litigation and what percent transactional?
It depends on the year, but I would say at least 60% is always litigation, and then 40% or less is transactional, depending on just what I've got coming my way that particular day or that particular month.
And Neil, you stole my question. Great job. We're on the same wavelength. Eric, so why don't you, well, maybe I should ask this first. Do you have any, obviously you have some interesting cases that you mentioned previously with the website EDA stuff, but do you have any other ones that were particularly notable that you'd want to discuss?
Well, I find it fascinating because I was dealing with an agricultural case in Ventura, and I was dealing with properties that were side by side. And so the northernmost property, I don't know if you know this, but there is a drilling moratorium in Ventura for wells, because the aquifer, most of the water in California and the western states is actually stored in the ground. It's naturally stored in the ground like a huge sponge. And so if you pump too much water out of an aquifer, it's called overdrafting it, and it actually causes the level of the land to sink. In fact, in the Central Valley, since the 1970s, the level of the land has probably sunk about 30 feet, just because they've been pumping too much water out of there. So what I had is I had a client who bought a security interest in a farmland area, and I was able to convince a court that included the wells that had been dug there. So I was able to get a receiver appointed and get the wells operational, and my client was able to form a water company with 2 operational wells in Ventura, which is really meaningful, because if you don't have water, you don't have much in the way of agriculture. And then the property right next to it was next to a golf course. And when we had the severe rains of February of 2017, the golf course was flooded. So they decided to pump all the water off the golf course, but they overburned a diversion channel, and it overflowed onto my client's 50 acres of strawberries. So I spent a couple of years fighting to get the access to water for the one property, and then the property right next door, I spent a year or so in an inverse condemnation action against the city of Ventura, because they flooded my client's strawberries and destroyed their crops because they had to get the excess water off of hole number 16.
Wow, that's a really interesting case, and what a spin-off twist of fate.
Yeah,
makes me appreciate those strawberries even more.
exactly.
So, as one of the newer members on our executive committee for real property, what made you decide to join the committee, and how have you found your experience so far?
Well, I decided to go into committee for several reasons. One of them was after, litigating cases for 30 years, I realized that many bench officers and many attorneys really don't have an understanding of real estate, and it's very difficult. I mean, I remember a case where we were able to establish an easement by necessity, but I was also trying to establish easement by reference to a subdivision map. Okay. And the judge who had the case, up until about a month before he had my case, was on the criminal courts, and nothing but the criminal courts for his entire judicial career. So to go from the criminal courts to implied easement by reference to a subdivision map was a really tough journey. And I find a lot of my biggest challenges are just educating who I would need to educate on the law of real estate. Because most people have an idea, but they don't have a very intricate knowledge of real estate. And what would be great if, like probate courts or family law courts or bankruptcy courts, we had real property courts, because it's such a complex area. So I felt the need, especially since I'd been doing it for so long, to provide some scholarship on the subject as well.
That's great. And what you're involved in any of the committees on real property? I can't remember if you're heading up any of the.
Yeah, I'm the chairman, or whatever you call it, of the litigation pack.
That's right. Yep. That's the one I was blanking on, so I apologize. But yes, you've done a great job with that committee, and I know you're all very active in providing us with a lot of material for our MCLEs and written articles and things like that. So thank you for that.
Sure.
And then what's something about you that people wouldn't guess that's a fun hobby or quirk or something entertaining?
Well, I mean, one of my favorite things to do is outdoor adventure. And so I do that through cattle drives and hiking and whitewater rafting. And so those I really enjoy. There's something very, very healing about nature. And then I also enjoy yoga. In fact, I'm starting a course next month to get my teaching certificate for yoga.
Good for you. That's awesome. I know we were so bummed you didn't get to do our guided hikes in Tahoe at the wellness retreat. Because
yeah, there was something about losing people in the snow so close to the Donner Party that.
Yeah, that blizzard threw us all off a little bit on our planning strategies, but everybody got there and made it in one piece. So.
Yeah, so.
That's awesome. I love that. Where have you gone whitewater rafting?
Gone whitewater rafting. I had a great event that I organized with a bunch of business associates or friends, depending on who you're asking. And we did what I billed as riding a snake through hell, because I like the imagery. So we went whitewater rafting on the Snake River through Hell's Canyon for 5 days. And wow. That was just wonderful. We got class 5s. It was just great. It was so funny because I was the one that selected the company, and there were 2 companies, and one of them was like how they're going to prepare luxury gourmet meals for you and give you luxury camping and luxury this and luxury that. And I said, well, I don't want to hang with those people. I know what they're going to be like. And so we were going through a class 5, and one raft capsized and one didn't. And the one that capsized were from the luxury gourmet trip. So I guess a cold bath was part of their luxury accommodation, but it was just amazing. And so I've also whitewater rafted on the Middle Fork of the Flathead River, which is in Montana. And then I've also done whitewater rafting on the Kern River. So that's been a lot of fun.
That's so cool. I've never been, and I've always wanted to go. So I'll definitely call you up to be my guide if I decide to go.
I'll throw in something personal here, which is in my younger days, I did a lot of whitewater rafting. And when I was in law school, I was doing an internship back east, and me and some colleagues went to, I think it was West Virginia, something called the Cheat River. And we stayed with a cousin of mine that had a ranch out there, and the night before, and he's talking to us, and he goes, you know why they call it the Cheat River, right? And we're like, we don't know, probably some Indian name. I don't know. He goes, no, because it cheats people out of their lives. Have fun tomorrow. So.
Oh, no.
Well, everything is fascinating if you live through it.
Yeah.
I was like, I went tubing on the river here in Austin, and that's nowhere close to even being remotely like whitewater rafting, but it was very enjoyable.
Yeah, I think once you commit to tubing, you're committing to not whitewater raft on that trip.
Yeah.
All right, so Ashley, let's finish up with our last 3 cases. So we'll kind of go through these pretty quickly, and then we'll allow time for discussion. Nunez versus City of Redondo Beach, This is basically a slip and fall case where, a woman who seemed to be an athletic woman coming back from, her morning run, tripped, later found out, there was a displacement on the sidewalk, conflicting evidence as to how, deep or high the displacement was, anywhere between 5/8 and 11/16 of an inch. So, between half an inch and a little bit, less than an inch. And of course, she sued, the city for not taking care of it. Trial court found, what, the offset was so small, it was trivial as a matter of law. The appellate court said, yes, in an unpublished part of the opinion, went through cases that said, yeah, basically anything less than an inch. Other cases in California have found those to be trivial. So the appellate court, agreed with that part of the decision. And in the published part, the court dealt with the issue of, well, the city had a policy that if it was brought to their attention and they discovered, a crack that was at least a half an inch, they would send somebody out to get it fixed. And so the plaintiff said, well, then they are admitting by their policy that it's not trivial because they get those matters fixed as a matter of course once it's brought to their attention. And the appellate court said, no, they may have that policy because, because they care about the welfare of their citizens, because they like, the way, the sidewalks look when they're repaired, et cetera. So that policy in and of itself does not change a trivial defect into an actionable one. Now I'm just going to quickly go through the other two and then we can come back and discuss whatever the two of you want. But again, all these three cases, they all concern, some kind of injury and premises liability. Joshi versus Fitness International, again, another, sad story. These injury cases are usually kind of sad. Joshi, after the workout, went into the sauna, closed the door. It was pitch black. The light was not working in the sauna. She was trying to go up to the upper level and the sauna fell down. Her arm came down on the heating element. And of course, she was burned, brought a claim against the club. The club filed a motion for summary judgment. The trial court said, well, wait a minute, was part of your membership agreement, you signed basically a waiver, an indemnity, a release agreement that applies to negligence. One of Joshi's claims was, well, wait a minute, that would not apply. The release would not apply for, gross negligence on the part of the club, and brought evidence that there was an inspection. And the inspection turned out to be the exact day of the injury. And so Joshi's saying they were on notice and should have either, closed down the spa, put a sign, put a warning sign, or of course, fix the light. And then the appellate court, and this is, really good for litigators, said, well, wait a minute. Yeah, we agree that releases for recreational programs are valid. But guess what, Joshi? You did not present evidence of when on May 1st that report was prepared. Was it prepared before you went into the sauna, or was it prepared at night? So you did not meet your burden of proof in this motion for summary judgment. And again, the ruling here was for the defense, was for the club. And then I'll just quickly, finish up this last case, Montes versus basically YMCA of Glendale, but it's not a YMCA facility. It's against an apartment building. And here you have a case. And again, all these injury cases, there's something sad, there's something horrific about them. And this one involved a death. And here you have a person after drinking liquor and eating a marijuana brownie at a New Year's Eve party. The Montes, the plaintiff, gets driven back to his apartment building at 2 a.m. Like at 4 a.m., he comes, back down into the lobby. There's somebody there for the apartment building, the manager, or the desk clerk, and says, geez, this guy's acting erratically. He leaves. Apparently, I guess the desk clerk was leaving for the day, at 6 a.m. and lo and behold, finds the plaintiff, on his car, severely injured. What everybody figured out is, well, probably he went up on the roof. It was a tile roof. There was a lot of broken tiles. It was slippery. It was steep sloped, especially in his condition. Probably when he was on the roof, just fell off and, landed on the desk clerk's car, like something you'd see in like a Law and Order episode or something like that. Unfortunately, Montes, was taken to the hospital and he died from his injuries. So his parents, on behalf of the estate, filed a wrongful death suit against the building owner. Trial court said, well, what's the basic rule? If you have an open and obvious dangerous condition, then there's no liability because the condition itself is notice to anybody who encounters that condition that it's dangerous, and you're putting yourself in that position. There are exceptions to that rule if you have to encounter the condition, which is not the case. You do not have to encounter the condition. The case was appealed, so it was judgment for the defense. Case was appealed. Kind of interesting case. Again, I think a well-written case. Reaches all the way back to Rowland versus Christian, something that many people remember from law school. Analyzing foreseeability, and as part of foreseeability, the court said, was it foreseeable that somebody would be up on the roof, this dangerous roof? And the court said, no, it wasn't foreseeable. There was evidence that people had been up on the roof, but then there was kind of a mischaracterization of the evidence that where they saw graffiti, it wasn't really up on the roof. It was up on the floor that had an entrance to the roof as opposed to the roof itself. And I put there my favorite quote from this case: there's a limit to how far society should go in order to protect individuals from their own stupidity, carelessness, daring, or self-destructive impulses. So I guess if you're drunk and high and you go up on the roof, maybe you're responsible for the injuries that happen if you're in that position. And I just threw on down there, the court did a lot of discussion of this case called Jacobs versus Coldwell Banker Residential Real Estate. And originally that case was not published. And on behalf of my employer, California Association of Realtors, I was involved in writing a letter requesting publication of the case. And it got published. And obviously it was influential on at least one court, on this court. And that's my summary of all three of them. So Ashley and Eric, whatever you want to talk to, I'll kind of flip the slides to whatever case you guys want to talk about.
Yeah, I mean, Montez, we're dealing with some stupidity here, in my opinion. And it's like, suing a building because you were high and drunk and did something stupid. I mean, that just seems wrong that the establishment should be responsible in those types of situations. But that's, and I think that's what they were saying with this case and what the law held on that one. And then on Josie, it's I found it really interesting that they, or Joshi, sorry, not Josie, Joshi, I think the language in the liability release was interesting too, because it covered accidental injuries occurring in dressing rooms, showers, or other facilities. So they used that to be broad enough to cover the sauna. And I think that that's interesting because I represent some Pilates studios, and I've written their liability release waivers for the exercise classes. So I'm pleased to know that these will actually hold up in certain situations where there's not gross negligence on behalf of the fitness center.
Okay. And do you want to comment on the other one, or should we just turn it over to Eric? Because Eric, you got something to say about all these cases, I would venture to say.
Well, I actually do. I actually read them this morning. First off, for Joshi, I'm of two minds, because I'm for limiting liability of businesses as long as they're not grossly negligent. But on the other hand, anybody who's ever signed up for a fitness center knows that those contracts are read with the same frequency as an iTunes user agreement. So You don't negotiate those agreements. You don't read them. You just sign them because you want to get on the treadmill. So that's an issue. As far as Montes, kind of reminded me is unintended use of a product. Okay, if you're using a chair as a ladder, is the manufacturer really responsible if you hurt yourself when you have an unintended use of a product? You don't intend to use a roof as a place to sit. So as sad as the result of the death to the young man, it was, I think the court was right. It's like, how much can you protect against? And then my only comment on the sidewalk case is that you have a lot of cases when when a measurement can be deemed insignificant as a matter of law. So there must be many cases as to how high a crack has to be before you can get to trial.
And that sort of goes back to, the ADA case and the website case, which is, when does something become judicially noticeable? And so for the Nunez case, it essentially became judicially noticeable because of the volume of cases that reached that same result, right? Hey, Eric, I have a question for you about the Joshi case. And because it seemed like part of the appellate court's decision really turned on the failure of Joshi. And when we say failure, really, it's not Joshi, right? Of course, it's the attorneys representing Joshi, for not putting into evidence when that report was actually prepared on May 1st. And of course, we're dealing with a motion for summary judgment, and not being a trial lawyer myself, I don't know, is that something that would normally come up at this stage? Is that something that would normally come up later? Do you have any thoughts about that?
No, it would definitely, it should have come up in the motion for summary judgment. I mean, there's plenty of time, because now, motion for summary judgment, 75 days notice. So if you're going to oppose a motion for summary judgment, you have plenty of time to do it. And what's too bad for the person who fell in the sauna is that the Court of Appeal was kind of saying you should have done it to the attorney. You should have done a better job at preparing your case in response to the motion for summary judgment.
So when you see a case like this with an opinion like that, does that set the attorney up for a potential malpractice claim?
Oh, yeah. Yeah, which is, there are many different aspects to it, but yeah, it really does.
Okay, and do you think it's because of the language that was used, or is just because of the result?
No, I think it's because the appellate court said that there was a way to victory, potentially, and this person's attorney did not take it.
Okay, and now, of course, I get involved in cases. Sometimes I write appellate briefs, like I mentioned, for for the other case, and sometimes there's strategic decisions that have to be made, and maybe the strategic decision turns out to be wrong in the end.
Right.
But it's kind of hard to tell because it's a judgment. Is this something that you think is a judgment call, or you think it's just a miss?
I think it's a miss.
Okay.
I mean, I agree with you because there's so many calls you make. Listen, I mean, victory cures imperfection. If you had a different judge deciding a different way, every decision you made would have been validated. But in this particular case, I think it was a missed opportunity. I don't know what the extenuating circumstances were, but I think it was a missed opportunity.
Okay, well, thank you. That's why, listen, Ashley and I have been doing this for a couple of years. We love it when we get a litigator because you can bring a sense and an analysis that at least the two of us who really don't go into trial court anyway, don't have a really good perspective on. So
What I would have liked to see, and I don't know if it was apparent, I just didn't catch it, is how long after the initial case was filed and how close they were to trial when this motion for summary judgment was heard.
Yeah, I don't recall. I did not pick up on that. And something that I actually did notice, and just myself sort of as a lay person, I will say, out there in the field, for all three of these, premises liability cases, and it's really no different than any other case that's making its way through the court system, but to me, it's really indicative as to the speed or lack of speed of our system right now, which is two of the cases, the injuries happened in 2017, and here we are 5 years later. And one of them, the injury happened in 2015. So that's 7 years later before we even get the opinion, right, from the Court of Appeal dealing with a pre-judgment motion. So there's still a lot left to go, unless these cases settle themselves up.
Which case are you talking about?
So the three, so Joshi, the injury was in 2017. And Nunez, the injury was in 2017.
Right.
So both cases were 5 years later. And then for Montez, the falling off the roof case, the injury was in 2015. Right. So
and just so you know, on Josh, I looked it up. The complaint was filed on October 30th, 2018, more than a year after the injury. And then the motion for summary judgment was granted in February of 2020. So a little more than probably about a year and a half after the filing of the lawsuit. And that may have worked into the courts granting the motion for summary judgment, because the time for expert discovery may have passed.
Thank you. Hey, Ashley, I see we have a question from one of our listeners. We're so glad we got a question from one of our listeners today. And it's could please send the case summaries to us after the Zoom. And what I would ask you to do is, we're happy to do that. So I'd say, send me an email with your address so that I can reply back. And send me an email directly at, is this okay, Ashley, or should I have us send directly to Beth?
Yeah, I'll type it in the chat too. Why don't you just say what it is though?
Yeah, so if you send it directly to me, Neil K, which is Neilk, Neil K at car.org, very simple, CAR.org. And yeah, so Ashley's putting that in the chat. Thank you, Ashley. Appreciate that. And then we'll be happy to send the whole PowerPoint presentation out to you. You know what? I see we have just a couple of minutes left. So let's do our typical wrap up. What's going on at the real property law section? Couple of interesting webinars, and they're live webinars. Sometimes we have repeats on here. We've got 2 live webinars. I really, they're both interesting. For me, who deals with, transactional issues a lot, I look at the September 29th, partnering with a litigator when you're dealing with commercial lease issues, right? So considering all aspects. So for somebody like me, that would be particularly interesting. Commercial leasing basics. I think that's one of our favorites, Ashley, right? Who's going to be putting that one on? Is that right?
Yeah. I think Joanne Woodsum did that one.
I think she's doing that too. Again,
I've heard that one's going to be particularly special.
Yeah, go ahead. We got a minute or two, so if you want to tell us what you think might be particularly impactful about that one, let us know.
Well, I was kind of making one of my funny jokes. I'm one of the presenters for that.
Well, then that's why. Then that's a really good reason. I did not know that, Eric. So that's a really...
I didn't know that you were on the panel either, Eric. That's
well, yeah, because the genesis of that, we were just having a conversation at some event, and I was talking to JJ and I believe Jennifer, And I was talking about how one of the aspects you learn when you actually try these cases is, are those provisions enforceable? Because if they're not enforceable, stop fighting about them in negotiation of the lease. And so I was just talking about a case I had where I had a trial court hold that a holdover rent provision was not enforceable because it was a penalty. So it gives you some perspective in what you're arguing over when you're negotiating a document. Can it actually be enforced in court?
And is that the September 8th one, Eric, that you're part of?
That's the one that you mentioned. I think it's the end of September.
The 29th, September 29th. Yeah, it made sense, but I wasn't quite sure when I was talking when you piped in. So sorry about that. So another extra reason to, go on and get an hour's worth of MCLE on September 29th from noon until 1. Want to remind everybody, the real property law section, we like putting on webinars. If you've got a great idea, Eric just mentioned, a great idea came up during a conversation. If you have a great idea for a webinar, we'd love to have you host a webinar. Contact Jennifer Swanson. See her email address up there. Again, you want to write an article for our e-news. We're always looking for short articles for our monthly e-news publication. You want to write something longer, basically law review type article, a lot of work. I just wrote one myself. You could contact our editor-in-chief, Norm Cherning. And Ashley, I know I'm going to see you in the middle of September for the CLA meeting and the gala. Eric, I didn't remember. Did you say you're going to go to that or not?
I am going to go to that. I have to leave at 6:30 on Sunday morning to go to one of my yoga teacher training classes, but I'm hoping that doesn't limit the amount I drink the night before.
I hope not, and hopefully some others who are listening will go onto the CLA website, calawyers.org, I believe, and look up the annual meeting and the gala, a black tie optional affair, something you don't get to do a lot of, and again, a lot of opportunities at the real property law section. Person, I see there's something else in the Q&A. Can we get a copy of this information page? Again, send me an email with your email address and I'll make sure that you get it, okay? So again, my email address, neilk@car.org. It's right there in the chat. We're right at 2 o'clock. So Eric and Ashley, I'll let the two of you have the last word.
Thanks so much, Neil. And Eric, thank you so much for being here and taking time out of your day. We really appreciate it.
Oh, thank you, folks. It's been great.
Thank you. Bye, everybody.